Chapter 17. Progressive Taxes. A Legal Precedent on Shaky Ground.
The incredible potential of the ABT tax system puts many arguments in its favor. But there is another consideration that should not be ignored in this day and age: the Supreme Court and U.S. Constitution.
And the Associate Justices of the Supreme Court of the United States. Oh yay, oh yay, oh yay. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to give their attention, for the court is now sitting.
With a conservative supermajority, the Supreme Court has shown its willingness to overturn established precedents on issues ranging from abortion rights to environmental protections. The Supreme Court has also eliminated protections for minorities contained in the Voting Rights Act, and conservative justices have ruled against LGBTQ and affirmative action rights. In this new legal environment, there is a real possibility that progressive taxation could be challenged by this court as well. All the way back to the ancient Roman Republic, policymakers debated whether the wealthy should pay more taxes than the poor. We continue this debate today. The idea of progressive taxation has been at the heart of this issue. Proponents believe that a graduated tax structure, where the tax rate increases as a citizen's income increases, is most effective. Non-believers assert that it is not fair to pay any amount greater than one's equally proportionate share, and that one's ability to pay should not be part of the equation. When the 16th Amendment passed in 1913, the U.S. adopted a tax structure that would become increasingly progressive over the years. Politicians and economists in favor of progressively increasing tax rates advanced the argument that this system was based upon a sense of fairness. The premise is that each dollar matters more to a poor individual than it does to a wealthy one. Foundationally, it is widely understood that one of the most important jobs of Congress is to appropriately distribute the tax burden among the population, and for many decades now, Congress has accepted this structure, or pretended to. But this could all change soon. In addition to the logistic challenges that we have previously discussed, wherein politicians and individuals have created ways to game the system, our tax structure has been met with many legal challenges over the years. The very constitutionality of progressive taxes has been questioned numerous times. One of the most compelling arguments is that progressive taxes violate the Fifth Amendment's guarantee against unlawful governmental takings. To date, the Supreme Court has held that progressive taxes are constitutional and fall under the government's broad power to tax. The court has also given judicial deference to Congress's choices over the many different types of tax to implement. However, those decisions were handed down by more philosophically balanced courts. A conservative supermajority could very well take a different view on these tax laws. The Fifth Amendment is often thought of as the Due Process Clause, specifically due to its stated criminal due process protections, such as the requirement of Miranda rights upon arrest, prohibitions on double jeopardy, and the foundational right against self-incrimination.
You have the right to remain silent. Anything you say can and will be used against you in the court of law. If you start to speak, but then decide against it, you are not required to continue. You have a right to have an attorney present during questioning. If you cannot afford one, the court will provide you one prior to questioning.
But the Fifth Amendment also requires that the government not deprive individuals of life, liberty, or property without due process. If the government does deprive an individual of property, then this is potentially a Fifth Amendment violation. In the past, complaints have proffered that progressive taxes do violate the Fifth Amendment of the Constitution. Specifically, the assertion has been that progressive taxes, with increasing tax brackets, unconstitutionally take money from the wealthy and do not compensate them properly. Not as frequently discussed, but possibly even more significant, is that the Fifth Amendment includes an implicit guarantee that each person shall receive equal protection from the federal government. Case law establishes that the Fifth and 14th Amendments to the Constitution require the federal and state governments to provide equal protection under the law to all individuals through the concept of reverse incorporation. This means that the Equal Protection Clause of the 14th Amendment, which specifically binds these guarantees onto the states, also binds the federal government to treat everyone with equal protection through the Fifth Amendment's Due Process Clause, even though there is no language of equal protection in the Fifth Amendment. This notion of equal justice under law has been long upheld by the Supreme Court as binding upon the federal government. This legal logic was detailed by the Supreme Court in the renowned ruling of Brown v. Board of Education.
The court ruled unanimously that racial segregation in public schools violated the Equal Protection Clause of the 14th Amendment.
In the companion case of Bowling v. Sharp, the court held that separate but equal schools in the Federal District of Columbia violated the Constitution, as although the Fifth Amendment applied to the federal government lacks an Equal Protection Clause, the Fifth Amendment's clause guaranteeing due process does include equal protection under the law through reverse incorporation. In following these principles, which stem from our American sense of fairness, the court outlined that discrimination may be so unjustifiable as to violate due process. Recently, the court ruled in SFFA v. Harvard that even affirmative action preferences for certain races violate the Equal Protection Clause of the 14th Amendment, which asserts that the Constitution requires all individuals to be treated equally. The history, the Constitution, and formation of the U.S. are predicated on the foundational notion of equality under application of law. This is the heart of the American concept of fairness. And so, to tax one individual at 15% of their wages and another individual at 35% of theirs is hypothetically a violation of equal protection under the Constitution. Likewise, providing exemptions from paying taxes to some special interest groups, and yet not giving similar exemptions to everyone, including exemptions that only the wealthy can take advantage of, possibly violates the notions of equal protection within the Fifth and 14th Amendments. If Congress wants to provide financial or material support to some groups, but not provide those benefits to others, they have the clear authority to do so on the spending side of the governmental equation. On the taxation side of the equation, where both money and property are taken from citizens, the authority is much less clear. So not only has the progressive tax structure in the U.S. been undermined by politicians who dish out exemptions and loopholes for special interests, but it is also based on a less than solid legal foundation. In light of this, one has to wonder if it's time to consider a better alternative. Replacing the existing progressive tax system with the ABT tax system would not only be more effective, but it would also be constitutionally fair and equal for all.